Hello, this is Matt on the Moon Lambo channel. Yesterday I published a video highlighting that the SEC, if you read through their motion for summary judgment, which is the last thing they're filing, or just about anyway, before Judge Annalisa Torres gets to make a final ruling in this case, they ditched some of their expert witnesses, including the unfortunately named Patrick Doody, who asserted that he knew why XRP holders were purchasing XRP. And there's no evidence that he spoke to any actual XRP holders, but he wrote up a report and he had an opinion, and he was, set to be a major component in the SEC v. Ripple case, especially when it comes to, end arguments, and he's nowhere to be found. And so I made a video explaining that and some of the implications and how disgusting it was, especially given that this guy, pulling from memory, I think that, or the firm he worked for at least, is getting paid like $600 an hour. And this stuff, if you look at all the experts, I don't know what the total numbers. I wouldn't be surprised if it's in the hundreds of thousands, if not, of dollars, if not greater than that. And it didn't even end up using the guy. Now, why didn't they use the guy? Well, today, attorney John Deaton shared some information exactly on this topic that I want to share with you. Because the bottom line is that attorney Deaton's supposition anyway, and I think this rings true, they think that their argument would have completely fallen apart. Well, first of all, it's obviously not true. Like, if they're going to assert that they know without having spoken to XRP holders. But going further, attorney Deaton, turns out he's filed over 2,500 sworn affidavits of XRP holders explaining why they bought XRP. And so it turns out that the XRP community being a part of this case is highly consequential, highly impactful, and it's resulted in the SEC fundamentally changing their strategy. Now, how baller ass is that? But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here's what attorney Deaton shared on Twitter just 8 hours ago, roughly. Even without an amici brief, XRP holders have already had a major impact on the SEC versus Ripple case. As I'm reading the SEC's motion for summary judgment a third time in preparation for our amici brief, I wanted to say thank you to the thousands of XRP holders who signed sworn affidavits. We submitted over 2,500 affidavits to Ripple and the SEC, testifying as to why and how people acquired XRP. Some including non-investment reasons, whether they knew anything about Ripple when they acquired XRP, how they utilize XRP, and the XRP ledger and use the decentralized exchange. Why do you think the SEC abandoned the expert offering testimony regarding what a reasonable XRP purchaser relied on when acquiring XRP? Do you recall the litigation involved with that expert? The SEC asked for me to be thrown off the case when I asked the judge to participate. So pause and think about this. And I remember reporting on this at the time, and it was just so offensive and stupid. And so now you can see why. They understand that if John Deaton gets to speak on behalf of thousands and thousands and thousands of XRP holders, it destroys the false SEC narrative, and they know it because they know they're lying. That all that comes out of that asshattery at the SEC is lies. Attorney Deaton continues. The SEC chose to not use this expert. Recall footnote 1, informing the court that this expert was offering these opinions despite not having interviewed a single XRP purchaser. If the SEC had relied on his opinions for its summary judgment, Ripple had a lot to use from XRP holders. And so he shared this screen grab from one of Ripple's briefs. And if you look at what he's talking about here, footnote 1 reads as follows. For context, the expert in question has offered opinions regarding the conduct and knowledge of reasonable XRP purchasers despite his not having interviewed a single person who purchased XRP. Pretty wild stuff there, isn't it? Attorney Deaton continues. Instead, there's no significant evidence establishing XRP holders relied on Ripple efforts or its promises and public statements. Read pages 53 through 63 covering XRP holders. It only talks about Ripple and the advertising and marketing. Nothing showing it was all successful. Think about that. And so, I mean, sorry, Ripple, if you were making marketing efforts to try and get end users to purchase XRP, you done failed, son. But as we know, Ripple is actually always focusing towards, strategic partners having to do with on-demand liquidity. And sure enough, I mean, fair to state too, in the earliest of days, yes, they very briefly did some XRP giveaways, but once XRP was traded on exchange, that whole model fell apart, because all you're going to do is just get people to take the free XRP and then just dump it on exchange. That model fell apart very quickly, unfortunately. But other than that, and even then, look, there were no promises and they weren't profiting from giving away XRP. So it's not like they were trying to get people to buy XRP. That's not what was happening here. And then Attorney Deaton says, why did the SEC choose to not use the expert? Because you chose to fight back. Most of the affidavits were notarized, requiring even more effort. The affidavits were from XRP holders from over 50 countries around the world. You made a difference. Isn't that cool as hell? Over 2,500 affidavits, and this is a sworn testimony, so there are legal implications with this, and many of them went to the trouble of having them notarized. Don't you think that this is going to be stunning when Judge Torres sees all of this? Nothing like this has ever happened in history. This is a first. And then there was also this. My fellow XRP YouTuber, Brad Kimes, wrote to John Deaton on this thread and said, so it sounds to me... here we go. So it sounds to me like the SEC is making the argument for XRP to be sold as a security, but not necessarily a security per se. Could this be an attempt to move it to a dealer broker and possibly accredited investor requirements in order to continue to get it? ? So I just want to say a couple thoughts on this. Ripple's already only selling to strategic partners. So I don't see what would much be gained, even if that were the SEC's approach, their attempt. I don't see evidence of the SEC moving in that direction. But also, what would, think about it, what would be gained though? Because if only accredited investors could purchase it, yeah, I mean, so even if they could purchase in the United States, that does, cut out almost 100% of, potential XRP purchasers. But, don't forget that doesn't structurally or functionally change anything about the way XRP moves on the rest of the planet. Because understand, something like 90 or 95% of XRP trading it's all outside of the United States, and that was before trading was shut down in the United States. So it's probably even worse now. I'm sure it's much worse now. So I'm not sure, and I don't see any evidence of going for this, but I'm not sure what that would even necessarily accomplish, and that's just the SEC being vindictive. Here's what Attorney John Deaton had to say in response to that. I don't think there's much strategy here, to be honest. I honestly think the SEC is flying by the seat of their pants and making it up as they go. Take Hinman's speech as best example. First, it was not guidance / his personal opinion / not guidance. Then it was guidance from corporation finance, but not SEC. It does seem like this is just a haphazard approach to, a jurisdictional legal land grab, effectively. That's what it looks like to me. And then there was also this. Somebody wrote in response to that first thread from Attorney John Deaton, I don't think he used the UK's affidavits in the end, only United States. And turns out, looks like that wasn't true, though. In fact, Attorney John Deaton retweeted that and wrote, affidavits are from international XRP holders' plight is included. International holders have a right to be even more mad. UK's Financial Conduct Authority says XRP is not a security, but SEC claims UK holders are in a common enterprise with Ripple and all other holders because XRP is a security. Yeah, so that's completely outrageous, obviously. And it's not like, so there's only one government on the entire planet that thinks that, but it's not even the entire government. It's one government agency within the United States federal government, the SEC. That's it. Nobody else on the planet is asserting anything even close to this. It's completely absurd. And then there was also this. It's on the same topic. Attorney John Deaton, and I'll just note this before I start reading this because I am going to read it as John Deaton wrote this. But in this first tweet, he cites the SEC complaint. So the SEC complaint, typically when people say that, they're talking about the initial legal complaint. But he ended up stating later on that he misspoke. What he actually meant to write was the SEC summary judgment motion, which is what was just filed a week ago. It's one of the last filings that you're going to see in this court case before Judge Torres gets to make a final ruling on this. So I'm going to read SEC complaint because that's what he wrote. But just know as we're going through this, what he's actually talking about is a SEC summary judgment motion. So here's what he wrote. Check this out. Reading the SEC complaint again, taking notes for Amici, it is embarrassing. They say things like, a blogger wrote, a Business Insider reporter said. And every single time, except once, that they say XRP investors relied on Ripple's statements, they have no proof to back it up. Now think about that. That is telling. It's not just that there are over 2,500 sworn affidavits from XRP holders saying, no, the SEC absolutely is incorrect. That's not why I was buying XRP. Not only does he have that, but even the SEC, other than one exception here, the SEC throughout that entire motion for summary judgment does not make arguments showing any sort of proof to back up the claims that they're making in terms of why XRP holders bought XRP. They're just making these wild claims. That's bogus. I don't see how Judge Torres falls for this. And then my fellow XRP YouTuber Crypto Eddie responded to that tweet from John and said, if the persons who contributed to that complaint were in the real world and had spent any time on Twitter, they would have quickly learned that shallow, baseless arguments don't last for even 30 seconds. Lucky for us, you've graduated to a pro level long ago. Thank you. Yeah, ain't that the truth? And then Attorney Deaton responded to that and wrote, thank you, Eddie, but I misspoke. I'm not reading the complaint again, but the SEC summary judgment motion, which makes it even worse because 2 years of litigation and collectively $200 million in resources have been spent to gain evidence, and the SEC cites bloggers, biased reporters, and tweets. Think about that. It is stunning when you put it like that. $200 million collectively, rough estimate, and that's a fair rough estimate because it's based on things that actually have been stated from sources associated with this, including Ripple. $200 million freaking dollars, and they're citing bloggers and reporters and tweets and not backing their claims up with evidence. I don't see how in a sane world the SEC comes out ahead for this. And I don't think they will, even if they get something out of this, because there ends up being a settlement and they make X amount of dollars and Ripple makes a concession just to get this done. Okay, fine. But I don't see how they're going to stop XRP, functioning and being bought and sold and being used within the United States or being listed as an actual security. I don't see how they win on any of those fronts. Their arguments are so scattershot. Like it's not going to work. Crazy stuff, right? I'll go ahead and wrap up here, but as always, I love hearing from you. And when I don't hear from you, I get lonely, and I wonder if I did anything wrong. So leave a comment in the comment section below, damn it. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.